speak with some degree of concern as to why the government has chosen to bring down the denomination value of these courts to such a low level. Mr. Deputy Speaker, sir, 2003, the 17th Law Commission had recommended 1 crore. The Commercial Courts, High Courts Bill 2009 had mentioned 5 crores as a benchmark. The 2010 Select Committee on Commercial High Courts, 1 crore. 20th Law Commission said 1 crore. The Commercial Courts, Commercial Division Bill in 2015 said 1 crore, but the Standing Committee on Personnel and Law Justice recommended 2 crores. It's of course every government, not just this government, the past governments also have dealt with Standing Committee reports, always in the breach. So Standing Committee reports are to be disregarded. Now, this is now brought down to an alarming 3 lakh level, which I am not able to understand at all as to what could be the rationale. Mr. Deputy Speaker, sir, it's a very piquant situation where by this piece of legislation, the Indian rupee is actually being sought to be given such an exalted value when the rupee actually today is touching 70 rupees to the dollar. This has been brought down to 3,000 rupees, 3 lakh rupees, which is virtually $4,500, and that is called a high denomination litigation in this country. I'm sorry, this is going to choke the courts completely. This was never the idea to bring about these commercial courts. These commercial courts, Mr. Ravi Shankar Prasad is a very eminent senior advocate. He's aware of what the original idea was to fast track these commercial disputes, because all over the world, India continues to labor with the poorest possible reputation for the dispensation and the quick disposal of high denomination, high value claims. Nobody wants to come to India and get embroiled either in litigation, which is via courts, or in arbitration, because neither of the two modes of settlement of disputes has seen a satisfactory redressal system, which is why this was brought in. This should actually have been taken with the greatest respect to at least 5 crores so that the real heavy-duty litigation could have been dealt with. 3 lakhs means I don't think this is now going to have any, there is not going to be a single case virtually, because I don't believe there is a single case today which has, nobody even bothers to go to court for 3 lakhs. Let's face it. If somebody owes somebody 3 lakhs, he's not going to go through the entire rigmarole of filing a litigation. So therefore, I don't understand. Therefore, every single commercial litigation is therefore now covered under this. Every single commercial litigation is going to go to these commercial courts. So therefore, what this has done is really relegated the position right back to where we were, which is there are ordinary courts which will deal with ordinary litigations. So I'm not able to understand what the government why the government chose this particular piece of legislation, and that too by ordinance route, to bring it to this honourable House. The second issue, of course, is the issue of appointment. There is no question that these fast-track courts also will become meaningless in any case without adequate appointments. The frightening situation today, and the Honourable Law Minister really has something to answer in this regard to this Honourable House. Live law today tells you that 143 cases of judicial appointments of the High Court and the Supreme Court are today pending with the government after the collegiums of the High Courts and the Supreme Court have passed those names and handed them over to the government. 143 names. We have roughly 800 judges in the High Courts. And all the High Courts today, I know for a fact, are all over 40% in terms of vacancies, which is a shameful situation when you are at 40 to 45 to 50% vacancy situations. I know the Honourable Law Minister repeatedly keeps telling us that so many judges have been appointed, but there are too few judges by far being appointed. I understand the Law Minister's sometimes anxiety that not enough names are in fact coming from the collegium as well, because I know for a fact that not just the Supreme Court collegium, where we've seen a huge amount of discord, but even the High Courts, I don't want to take any names, but even the High Courts, the collegiums have massive discord, as a result of which there is no unanimity on names being given to the government. So government alone is not to blame. I may want to make this clear, But government is also to blame, because at least the names that have come to you, and I don't want to mention particular names here, but the manner in which names have been sent back, manner in which names have been kept back, manner in which government has sat over files. Yesterday, a PIL has been filed in the Supreme Court saying government must be given a mandamus that within 6 weeks of the collegium giving out names to the government must clear those names. That's a petition filed in the Supreme Court yesterday. So this is a very unedifying situation. This is not a happy situation for this country, particularly when the country's law department is headed by such an eminent counsel, and who really ought to ensure that this system flourishes. The system of the Indian judiciary must flourish. This Indian judiciary, unfortunately, today is not flourishing, Mr. Deputy Speaker. It has virtually become moribund. It has come down to a very sorry pass. And I'm sorry that this piece of legislation is going to further add to the burden. So I don't understand the reason, the rationale for this piece of legislation being brought to the House. Therefore, I find myself unable, frankly, to support this piece of legislation. Thank you very much, Mr. Deputy Speaker.